Good morning, everybody, and welcome back to Coffee with Craig, where we talk about firearms policy. We talk about firearms in the news, media, firearms culture. You name it, we're talking about it right here on Coffee with Craig. Very much appreciate you once again tuning in. Please take a moment to like and share this video feed so that your friends can join in the conversation. Also, make sure to subscribe to our YouTube channel and follow us on Facebook. If you're watching this pre-recorded, if you want to actually get the alerts, if you go there and you sign up, then you can go ahead and you'll get the alerts as soon as we come on, and you can participate in the conversation as it is happening. Also want to remind you, a great way to support the program is to support our sponsors. That would be Sacramento Black Rifle and Sparks Black Rifle. All you got to do is look them up on Facebook, Instagram. They've got tons of really cool stuff, and once again, they support us as we support your right to keep and bear arms. You can also support us directly via fpcgear.com. That's fpcgear.com. You can get all sorts of cool T-shirts and whatnot, and know that every dollar that you're spending there goes to help support your constitutional right to keep and bear arms. Okay, now that we have paid the bills, let's get into today's topic. Some of you may have heard recently that the California State Supreme Court has actually upheld California's ban on new model semi-automatic handguns in the state of California. Now, that's not what they're calling it. What it is that there's a microstamping requirement. There's the microstamping requirement for the not unsafe handgun roster, meaning we have a roster of firearms that are available for sale in the state of California that are considered to not be unsafe because California government could never call a gun safe, so they call it the not unsafe handgun roster. And one of the things that they have as a requirement for that is this thing called microstamping. And they require microstamping on the shell casing, which is ejected from a semi-automatic handgun. It's required in at least two places on that shell casing. Now, the problem is that as the manufacturers have stated, there is no way in which they can comply with this. The technology does not exist for them to be able to comply with this particular requirement, which basically means they can't sell any new model handguns in the state of California and have not been able to since 2014. Now, this was a law that was actually passed much earlier than that in 2008, but since someone was holding the patent and then the patent eventually got renewed, it actually didn't take effect until 2014. So what is happening in the state of California is we're seeing a significant decrease in the number of new model handguns that are available. Not only that, even the models that are already on the not unsafe handgun roster, as they change their parts, whether it's a new spring, a new trigger, anything minor that might, a new color for the firearm, anything that might potentially change that firearm changes the model, and therefore now it has to comply with the new requirements for the not unsafe handgun roster, which in this case is microstamping. Once again, microstamping technology in particular, in this particular case, that doesn't exist, which is the ability to be able to put it in two different places. So this was argued by the National Shooting Sports Foundation before the California Supreme Court that, hey, this law is invalid because, well, it is impossible to comply with and therefore should be thrown out. Well, in their infinite wisdom, the California State Supreme Court has in essence ruled that, well, no, because a law is invalid, just because a law is impossible to comply with does not mean that law should be invalidated. I know they're saying it's constitutional to have a law in place that is impossible to comply with. Now, what they did note in their defense, what the California State Supreme Court did note was that that might be a reason for not actually enforcing the law, for not putting some sort of enforcement or punishment against someone who is violating the law. But yet and still, it doesn't necessarily mean that they need to invalidate the law. Now, while there are those who I've heard argue that there is some legal precedent behind this, and what they use, for example, is California state emission standards, where their whole goal is to pass these laws that require these things that, even though they don't exist, the whole idea is to push industry into innovating in order to be able to do what it is that they want them to comply with. The problem is that when what they are asking is in fact impossible. I see, because here's the thing. This is what I find it hard to believe, and this is the argument that I make oftentimes to folks who keep pushing this microstamping thing, saying, well, they just refuse to do it. And I'm like, do you really think that there are companies out there that don't want to sell their product to the largest market in the nation? Because yes, California has the largest market in the nation. And by the way, while we may not necessarily have the highest per citizen firearm ownership per person, we do have, I believe, the most firearms in the entire country. There are more people that are buying firearms in the state of California, that own firearms in the state of California, than probably just about any place else in the entire country. So clearly, this is a market that the gun industry wants to be in. They want to be able to sell their new model firearms here in the state of California. How do I know that? Because when you look at when they put the requirement for the loaded chamber indicator or the magazine release, when they did that, manufacturers, even though those of us in the 2A community, even though shooters were like, no, we think this is a bad idea, guess what? They still started to put them out. Why? Because they wanted to sell guns here. They wanted to sell their new model firearms here. So why wouldn't they want to be in this market? Why wouldn't they try to comply so that they can sell their product? Because keep in mind, in the end, Ruger, Smith & Wesson, all of these companies, while yes, they do want to help promote and encourage us and allow us to exercise our Second Amendment rights, let us understand something. First and foremost, they are businesses, and they have a profit motive. And their profit motive is they want to sell as many of their products as they can. They want to have as big a market to sell their product as they can. Why would they not want to be in the state of California? And if they could, why wouldn't they? And that's the important thing to understand about the California requirement. It doesn't just require it in one place where the firing pin hits the shell casing. It wants it in two places, which, by the way, as the industry has said, is impossible to comply with. On top of the fact that even if you did have it in just one place, you're now going to have a requirement. There's all sorts of other reasons why it's problematic, but ultimately it's impossible for them to be able to comply with. And so therefore, we don't have access to the same firearms that are safe and in common use in other places in the country. Now, this case got thrown out, or this case basically got thrown out or out of the California State Supreme Court, which means that there is only one lawsuit currently that exists right now dealing with the not unsafe handgun roster. That would be Pena v. Lindley. It's currently before appeal before the Ninth Circuit Supreme Court. Yeah, I know exactly what you're thinking. If you want to see, by the way, I encourage you. We have the highlights, a link to the highlights of the oral arguments that took place over a year ago. That's how long we've been waiting to hear from the Ninth Circuit. But we have the oral arguments. I have them linked in the description of this video, and you can really get an idea of what's going on here. Because, in the case, in the NSSF case here at the state level, a couple of things were noted. Number one, they didn't argue a Second Amendment challenge. They also didn't make it a point to, and this was one of the things that was noted in the opinion, they probably could have or should have challenged the certification by the California Department of Justice that the technology existed, because that was one of the requirements of the law, was that it had to be certified by the California DOJ that the technology actually existed. And while, yes, the technology may exist to put it in one location, the technology does not exist to have microstamping in multiple locations. So who knows? I don't know what NSSF's plans are. I don't know if they plan on going back and trying to address that. But I can tell you this. I can tell you that it is crazy to think that according to the California Constitution, according to California law, that there's nothing wrong with having laws that cannot be complied with, that are impossible to be complied with. Because see, that is exactly that. You know, it's funny. That's almost similar to exactly what happened in the case of, and this is actually a case that was directed by the federal Supreme Court, and that is Teixeira Alameda, where they passed a zoning ordinance that made it impossible to open a new gun store in all of the unincorporated county, Alameda County. There was no place that fit the new zoning requirements in unincorporated Alameda County in order to open a new gun store. Zero. And because the Supreme Court refused to take up the case, the Ninth Circuit's decision to allow it to stand, allow that sort of ban on gun stores in the unincorporated county of Alameda to stand, even though the law was impossible to comply with. Folks, once again, these are dangerous times. All I can do is tell you that these are dangerous times. This is why it's also vitally important, in particular, that we're pushing President Trump to make sure that he fills those vacant seats on the Ninth Circuit. There are currently, I believe, 8 or 9 vacancies on the Ninth Circuit. We need those filled, and we need those filled with people who believe and support the Second Amendment. That's number one. Number two, we need to make sure that whoever that is going to be the next Supreme Court justice, and we've just heard who that individual is who's been nominated. We hope that person gets confirmed, but we need to make sure once again that person supports the right to keep and bear arms, because the Supreme Court and the Ninth Circuit, for those of us who live in 20% of the nation who are stuck in the Ninth Circuit Court of Appeals, we need our rights back. We need a judiciary that's going to stand up for our rights. Anyway, that is quite a mouthful. Hey, I want to encourage you guys, please, that's going to be it for today's Coffee with Craig. I want to encourage you guys to please like and share this video feed. Please tell people about the Firearms Policy Coalition. Tell them about the work that we're doing, whether it's in the courts, whether it's in the legislatures, or whether it's just right here communicating to the people. Let people know about the Firearms Policy Coalition. We are the home in the fight for civil rights. Remember, we got to use them or we're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.